All right. So thank you so much for joining us today, and I will allow a few seconds until the attendees start entering the room. First of all, my name is Gaia Rizzi. I'm Marketing and Events Manager for Eastern Communication and Events, which is a company of DP Group. And here with me, my colleague Divya Hazra. She's legal advisor for Dante and Partners Legal Counsel. Today, we have the pleasure to go through Vietnam's draft decree on personal data protection, and we will have the pleasure of having Mr. Michele, to whom I will give the floor in a second, chairman of ICHAM. Then we have the honor of having Mr. Dante Brandi, who is the Consul of Italy in Ho Chi Minh City. And then Divya, she will moderate a very insightful panel discussion with our two guests, and she will have the opportunity to introduce them better later. So without any further ado, Michele, I leave you the floor for your opening remarks.
Thanks, Gaia. Of course, thanks to all the DAP team. Thanks to our Consul General of Italy here in Ho Chi Minh City and all the participants. We are in April 2021 and we'll still continue the series of webinars that we organized since last year with ICHAM in collaboration with DAP, and was very successful seminars last year, many topics we of course we talking about. And also we started this year with very specific topics about a draft decree on personal data protection. This draft decree was already starting in Vietnam to talk about a decree in 2019. And on 9 February 2021, the Ministry of Public Security released the second version to collect public opinion until 9 of April 21. And then, of course, Mr. Filippo will go deeply about all the details of this draft. It's very, sensitive topics. Personal data protection is, in the world, we are in Italy, we are Italian, we know what it means privacy. And also in Vietnam now, they are talking deeply about any details of this or about the data protection. Of course, we will continue as ICHAM to support webinars with DMP. We will have probably in May another one, and we will continue to do this year. The main reason of these webinars, of everything starting due to the pandemic, was the bad reason, but the good reason is thanks to this webinar and Zoom, we can reach many people, in this case not only Vietnam, China or Italy, on our topics. And we can, the most important things for us is ICHAM to be updating the business community about many you can say topics, different topics related especially to the companies that are here, Italian companies, they are here present in Vietnam. Because of course, last year was quite complicated also for business point of view. Also this year, little bit better in Vietnam, the situation, but still very difficult to have, international travel open. This facing some problem in many sectors. So the company, especially located in Vietnam, would like to know what's going on in the future. So we will try to update them about the other many important arguments, also related to the open of the border. Probably we have no idea yet. The governor of Vietnam just starting, they enter into force just a few weeks ago with the new prime minister, new president of the republic, and so on, National Assembly chairman. So everything is new ministers. So we don't know yet what happens about the future. That very interesting, problems that Italian, not only Italian company, they're looking to know how was going on for the next part of the year. How can the business can grow, especially with the improving the export or import. So we will try to stay very close of this problem to try to update our members, not only but all the Italian company business communities here in Vietnam. So this is for me, and I will give the floor probably to our Consul General, Mr. Dante Brandi.
Yes, thank you so much, Michele, once again for your support with the Italian Chamber of Commerce in Vietnam. It's always a pleasure for us to have the opportunity to cooperate to organize this kind of webinars. And now, as I mentioned before, and as you just said, we really have the pleasure to leave the floor to our Consul General, Dante Brandi. So please, the floor is yours, and we're very much looking forward to hear your opinion.
Yes, thank you very much, Ms. Gaia. Thank you, Michele, for your words, and thank you for sure to D'Andrea and partners for organizing this very timely event, and to Exprivia, of course, and all to the panelists, speakers, and moderators involved. It's a pleasure for me to attend this webinar, because, of course, my presence is consistent with the support that all Sistema Italia, both the embassy in Hanoi, the Consulate General in Ho Chi Minh City, the Italian Trade Agency, and the Italian Chamber of Commerce is devoting to support Italian companies, but also local businesses and international companies working in Vietnam or approaching the Vietnamese market. This occasion is particularly interesting because we will hear comments about an in-depth analysis, I guess, on the draft decrees on data protection set up by the Vietnamese government. My comments is that we read this new legislation as a consequence of the openness of Vietnam to international markets. Vietnam is a very integrated economy. It has always been. This approach is consistent with the nature of its economy, because Vietnam is a manufacturing platform, is becoming a growing consumption market, of course, but it's still predominantly a manufacturing platform, which implies, of course, is an economy attracting a lot of foreign direct investments. So many international companies are set in Vietnam or have chosen Vietnam for their manufacturing activity. And so I think Vietnam is now in need of setting a legislation regarding data protection in order to comply with international, more than international legal standards, of course, but also with international economic standards, in order to get integrated into this supply chain, which is crucial for its economy. You all know that Vietnam has struck two very important deals in 2020. I'm referring to the European Vietnam, the EU-Vietnam Free Trade Agreement. Of course, I'm referring to the CPCC, which was the result of the Vietnamese ASEAN presidency in 2020. A very important and relevant commercial deal with ASEAN countries, enlarged ASEAN countries, including China, of course. And this, of course, is consistent, as I said, with the approach of an integrated economy into a global market. I think also this effort of this new legislation on data protection is consistent with an effort of codifying a relevant, of course, topic, which now I think in the Vietnamese legislation is scattered into different pieces of legislation. So it would be important also to listen to this analysis from the expert today. What is very interesting is about this seminar is to listen to the expert evaluation on the approach the Vietnamese legislators and decision makers have taken in order to set up this new legislation. In this case, I of course cannot but mention the data protection system, which is now in force in Europe, and which you all know, of course, and is still related to the famous GDPR, of course, the General Data Protection Regulation, which oblige all the member states to follow again this legislation. and which is an evolutionary piece of legislation because it's a different philosophy, of course. It shifts the vision of data as a property, which implies, of course, that you cannot use a data without the consent of the interested party, to a data as an asset to be controlled. And this, of course, facilitates the free circulation of data, but in the meantime, it reinforces the rights of the interested party, who must be placed in a position to know if and how his, her, or its data are used or will be used. And so it's a risk-based approach, which is showing since the last 5 years, since the entry into force of this regulation, its effectiveness over the years. And of course, it has consequences to employees, employers, and all relevant stakeholders managing data in European Union. So it would be nice to listen, of course, which kind of approach the Vietnamese legislator have taken in order to draft this new legislation. And a final comment is, of course, again, on the reading of this piece of legislation in view of the challenges the Vietnam or opportunities that the Vietnamese economy will present in the near future. I'm referring, of course, to the e-commerce explosion or evolution. All analysts are, of course, looking at Vietnam as the next India, where everyone expects that the e-commerce and marketplace, electronic marketplace will boom more or less in the same way India did over the last 5 years. But also the new challenges in manufacturing system, like artificial, and in service, of course, like in the introduction of artificial intelligence in manufacturing and in the management of productive activities, of course. So this includes, of course, the managing data from the side of the employers, so companies active in Vietnam. And of course, this will have consequences from the moment the new legislation will be in force, which I understand is going to be December the 1st, 2021. So I really thank once again the organizers for this opportunity, and I'm really keen to listen to the experts on their views on this new legislation and the consequences it might have on companies active in Vietnam, including, of course, Italian companies, which are at the core of our institutional mission to support here in this market. So thank you once again, and I wish you a fruitful webinar.
Thank you very much. Your comments have been, I think, very much appreciated, especially because, as you said, the relations between Italy, Vietnam, and also the possible impact that this new draft can have on the business in Vietnam is extremely relevant. And as we will see in just a few minutes, our legal advisor, Filippo Scaglia, who's connected from our Hanoi office, will get into more details, and then we'll get into it even more during our panel discussion. And then now, I will just quickly share with you our company presentation, especially for those of you who haven't participated to any of our webinars before. I promise I will be short so we can get into the details of today's topic. So first of all, as I said before, we are DP Group, an international consulting firm, and our mission is to be present in every business capital of the world to make the global business environment better through our work. So as you can see, as of today, we have 9 offices between Italy, China, Vietnam, Dubai, India, and also a Russia desk. And among our strengths, we have many, such as a very strong network, international experience, publications, and webinars and events as the one that you're attending today. Our structure. So we were founded by Mr. Carlo D'Andrea and Matteo Ge, and as of today, DP Group counts on 4 companies, which are D'Andrea and Partners Legal Counsel, and today we have both Divya and Filippo representing the company. And our law firm is specialized in several practice areas, from corporate and commercial law to dispute resolution, relocation and negotiation with local government, and so on. Then we have PhD Advisory, Tax and Accounting, and the name is self-explanatory. It's our company that deals with accounting, financial supervision, M&A, and overall business consulting. Then Eastern Communication and Events that I have the pleasure of representing here today. And we're based in Shanghai, and we're specialized in social media management and events. So overall, we do communication consulting. And then our latest company, Chance and Better Education, which is mostly focused on providing training and education programs to both students and C-level managers. Then we have the great opportunity to publish practical guides. So we have extensive publication in China, but also internationally, and we have been focusing a lot on Vietnam as well lately. So if you're interested in getting any of our guides, feel free to get in touch with us by email, or you can find them also on Amazon.com. And here, just a final overview of our offices, whether you would be interested in inquiring with us among our activities and companies. Now, without any further ado, I really now leave the floor to Filippo from our Hanoi office for his presentation, and he will be focusing on a legal overview of this upcoming draft. So Filippo, the floor is yours.
Okay, thank you, Gaia. Thank you for the introduction. Thank you to the Consul General, and thank you also to Mr. Berkole. Now let me share the screen so I can start with the PPT. Okay. Okay, here. And like this. Okay. So I really will try now to give a basic, and try to catch the whole picture and the whole framework for this new regulation that is going to be introduced here in Vietnam. I will not go through all the articles of the decree because I believe that, first of all, it's going to be boring, but not all the articles are interesting, and I will try to analyze the provisions that are most relevant for businesses and for here in Vietnam, mostly for Italian business, but for all the European businesses and foreign here in Vietnam. So, as a general picture, the decree was the first draft of the decree was published and approved in 2019. The one we are talking about today is from last February, and officially it is foreseen that the final draft, so the law, will enter into effect in December of this year. The main news regarding this decree is, first of all, it applies to any agency, organization, and individual that are involved in personal data. So it's a very broad scope of application because it involves anyone basically, from the customer, to the institution, and to private sector. Anyone which deals and manage with personal data will have to comply with this provision. It foresees also the establishment of the committee, of the local committee, which will supervise and ensure the compliance with the law. And now we'll get to the definitions that are provided by the decree. First of all, this is the definition of personal data and the categorization into.
Sorry, 1 second. I don't know if it's a screen problem, but we can only see the first slide of DP Group.
Okay, can you see it like this?
Yes. And
okay,
so to expand the screen so to get it into presentation mode so we can follow better.
Okay.
Thank you.
So, as I was saying, there are two types of personal data: basic and sensitive. This definition this categorization is important because the sensitive personal data, of course, are subject to a more strict regulation, and so they are treated more carefully, and because they need a more strict protection. The subjects involved are the data subject, which are the end user and the final customer. So the person of the individual to which the data are referred to. The data controller is one of the main actors, but it is not defined by the decree. The data processor, which are we can say the companies and all the players that are involved in the compliance with the law. If I can make an example, we can say that in every day, the data subject is the client, the customer. For example, I can think of a tourist coming from Europe to Vietnam, which enter the country and go on a website and book a tour with the Vietnam travel agency. And the data subject is the tourist, the data processor is the Vietnam tourist agency. So these are, you can see, is not, even if it sounds composed and very high, it really affects and impact everyday transaction of everyone in Vietnam. What are the rights of the data subject? So these are the main provision for the data subject, so for the individuals, because the person will have to give consent and has the right to disagree with the data processing, and also the data processor shall notify the data subject for when he starts to process the data. So these two steps are quite reasonable, and this is what this law is about. However, they are quite burdening for the players, for the business subject that operate in this sector, because they will have to ask the consent to receive the consent, and they will also have to notify the data subject for every act of processing the data. These require not only time but also resources, because as of today, we don't believe that businesses are ready to comply with this regulation. They don't have the resources, the numbers, and also the human resources to comply with the consent and notification system. Then the other rights are also, of course, the request to view, to edit, to provide copies of the personal data, and then in case of a violation, they can also file complaint to the committee and also claim for damages. But we'll get into this later. Regarding the data processor now, first of all, as I mentioned before, the decree provides for the establishment of the PDP committee, which will supervise the activities of the subject involved in the data processing. And the data processor, for when is processing sensitive data, he has to obtain he has to register the processing with the PDP committee. The procedure to register with the PDP committee is first of other than file an application, it also provide for an impact assessment report. This report should include the processing activity, the purpose for the processing, and also should assess the potential harm to the data and the measure to counter, to minimize, and to manage the potential harm to the data. So it is quite a long process. It is not automatic. It's going to take time to make it automatic. And second of all, the decree provided that the committee has as long as 20 days to issue, to accept, to approve the registration. So other than provide all these documents, all this information, it also takes time to obtain the registration. Then for the data processor, the other point is the application of measures to protect the data, because according to the decree, the data processor should implement, should appoint a person inside their business, inside their companies, inside their businesses, which will deal with the data collected and stored, and also shall issue the internal regulation regarding the processing of the data, which of course should comply with the law. The committee, exactly, I already talked about this in the establishment. The committee will be composed by 6 persons, and there is actually not much information about this in the decree, but we expect that their activities will be to supervise and to manage to ensure the compliance of all the players involved in the data processing. Regarding administrative sanction, first of all, you can see that they are quite reasonable, because for the first violation, it's only a matter of the fine, while for a repeated violation, for the second time, for the third time, it goes up to 5% of the total revenue generated. Anyway, we believe that the additional sanctions might affect most businesses involved, because the suspension of data processing for 1 or 3 months could put out of business some activities, and could be, you cannot operate if you cannot process the data coming from your clients. So these additional sanctions are actually quite effective in our opinion. Now, to get to the end of it, let me give you some key takeaways on this new draft decree. First of all, the broad scope of application, because it involves any agency, any institution that deals with data processing in Vietnam. Second of all, the matter related to the sensitive personal data and the registration with the committee, and also for the cross-border transfer of personal data, which is a quite burning process to obtain the approval and from the committee. Second of all, the definition of the sensitive personal data. Then again, I forgot to mention before that the data processor should also implement a system to store the data transfer history related to sensitive personal data for a 3-year period. This again is a burdening provision for companies, because they will have to implement a structure and also the human resources to manage all these data. There is no grace period provided so far, so we hope that there is at least 1 year or 2-year grace period to give time to the people involved in this business to comply with all the regulation. The difference between the basic and sensitive data, the 5% of the total revenue as a maximum fine for the violation, and then again the official date, which is expected to be December 1st of 2021 for the entering into effect of the data decree. That's all for me, and I hope it was all clear. If you have any question, and I'd be glad to answer later the question and answer time.
Thank you, Philo. Now, without further ado, I'll start with our panel discussion today. First, I would like to introduce our 2 panelists. So today we have with us Mr. Bruno Sivanandan and Mr. Simone Ciampi. For the benefit of our attendees, I would give you all a short introduction of both of them. Well, first, Mr. Bruno. He is a member of the Digital Sector Committee at the EuroChambers, and he's the head of the PDP task force. So obviously, he's one of the best guys in this current scenario to explain, or if you have any questions, or explain the decree to you. And we'll be getting into the depth of it with him with some questions that we've identified. Welcome, and thank you so much for joining us today, Bruno. And our second panelist today is Mr. Simone Ciampi. He is the general manager of Exprivia IT Solutions here in Shanghai. Exprivia IT Solutions is a leading Italian company in the ICT market, and he has been successfully operating in the Chinese markets in 2014. The idea of having Mr. Simone here is to kind of draw an analogy between the existing decree in Vietnam, compare it to the EU GDPR, along with giving an entire broad view perspective of how data protection is actually applied to in China. Welcome to the panel discussion. And I would actually first start with a question to Mr. Simone. So Simone, our question to you is, how can the EU GDPR, that is the European Union General Data Protection Regulations, and the Chinese Authority for Data Protection access and check the compliance of any company? The floor is yours.
Thank you for inviting me, and it's a pleasure to be here. Yes, I mean, actually the point here is there are two ways for the let's say for the regulators to check the compliance of the companies, and it's both off-site and on-site. Off-site, it's I mean, they may require you details and explanation of what are your policies and if they are really implemented according to the regulation. And on-site is referring, of course, of on-site checks, and of course, they will assess directly on site if you are doing all the measures. For example, here in China, I mean, actually the regulation it's going to be similar, I think. And even if the Vietnamese one is really general for the moment, but I think that the processes and the steps they're following they're pretty similar to the Chinese one. And for the moment, they are implementing both, but mainly the off-site checks. So basically, if they get information or they want to collect information of specific companies, and for the moment, they are starting only for the very big ones. So they are not starting with the small companies, but they're starting with the biggest one, and the one more affected with national or very important sectors or markets. What they call here network providers, or affecting the national security and whatever. But what they're doing now, so it's mainly assessing, asking for more information, checking if you have deployed a policy, what kind of policy, how you store data, if you are using a correct way to protect your data from intrusion, both, I mean, real from physical and online. And in case they find some uncompliance or inconsistencies, they process with an on-site visit and check.
Noted. And is it complicated to deal with the authorities, like when it comes to an on-site check? Like, how do you deal with that process? Have you had a similar experience like that?
For the moment, I mean, actually, it depends on the sector you are dealing with. But for the moment, I mean, actually, for the moment, it's really not a strict implementation of the law. So it's a kind of soft approach.
I see. And I mean, as a part of any of the European countries, you think the approach is much more stiff compared to that in China?
The European one is much stricter, but it has been implemented much before. So I think it's I mean, Chinese authorities are really, for the moment, just going step by step, giving time to the companies to be compliant with the law. They started 2-3 years ago. For a couple of years, they just really, I mean, the regulation was very similar to the Vietnamese now. So it's really general, but saying that, okay, we are doing this, pay attention, and step by step, we will be stricter and stricter. And now they are starting, so they are putting some more application or regulations, so they are going in details, and so step by step, of course, companies, they need to deal with this.
Okay, understood. Thank you so much. Now, my next question is for Bruno. And with Bruno, the idea is to get a bit more technical, considering he is heading the PDP task force. I think he'll be a great source to really understand the implications of the regulations in depth. So our question to you is, can you please give us an example of processing of personal data for legitimate interests as has been noted in the decree? What would be
Okay.
your interpretation of it? Thank you.
So thank you for introducing myself. So I'm very happy to be here, and I'd like to thank DP Group to organize and even welcome me in their office for logistic reasons. As for the question about legitimate interest, I think it's important to introduce beforehand the concept of lawfulness of data processing, because we introduced the concept of data controller, which is responsible for any data process. And it is very basic. It's the first thing you need to consider, that any data process is lawful. And for a specific data process to be lawful, you have an array of options. Well, the first one is the consent, and another one is the legitimate interest. So how to define this concept is like any company may claim that one data process is in their own best interest, and even could be in the best interest of the data subject. And once you made that claim, you need to prove that a given data process is indeed necessary for the purpose of the legitimate interest. And after that, you need to ensure that you strike a right balance between the legitimate interest you're claiming and the human rights or basic rights of the data subject. So that is kind of the context of the concept of legitimate interest. And so that's a bit abstract. So let me take a few examples. For instance, if you have a transportation company that owns trains, and an influencer, a public figure, posts something on Twitter or social media claiming that the train was overcrowded, terrible experience. Now, this can damage the brand image. So it is in the legitimate interest of the company, the transportation company, to defend itself against what might be a false claim. And for instance, if the company has footage of the said train showing that there were empty seats, it is in the legitimate interest of the company to show this footage and to prove that the claim from the influencer, from the public figure, was false. So that's the purpose. But in order to do so, they need to show faces from people that were on the train, and that is crossing the line of some privacy. So a court will rule between those two. And for instance, if the company indeed has been showing the faces of those people, is it really serving the purpose? And in that case, maybe it's not, because like you can definitely prove there were empty seats without showing the seats of the people. So I hope this is clear, and I think it's a good example to illustrate what is the legitimate interest and how to actually have it with a concrete example. And so I just conclude with the answer by pointing out to Article 10 in the draft Personal Data Protection Decree, which is kind of relative to that without having the concept of legitimate interest being introduced as such.
I see. And do you think that there needs to be more clarity under Article 10 to kind of make sure that it's more coherent with the concept of legitimate interest?
I do. And in a more general manner, I think the whole draft decree needs clarification.
Sure.
So Article 10, but not only Article 10. So this is mainly what we have been advocating through the EuroCham.
Mm-hmm.
So for more clarification. So I will not provide too much details, but yes, that's my opinion.
All right. Thank you so much. So now we move on to the next question, which is again for Simone. So again, drawing a parallel between China, the EU GDPR, and the decree which is to be enforced in Vietnam. My question is there any coordination currently between EU GDPR and the Chinese Authority for Data Protection? And would it be beneficial for international companies if there is such a correlation?
There is no coordination. I mean, actually, they are two, completely separated authorities, regulations, and also, let's say, assessment of compliances. So actually, they're not talking each other. I don't think they will do in the future. I think it's almost impossible. The only connection for sure is that some of the policies and the regulations implemented in China are following or are taking inspiration from the European one, but not only. But this is the only connection for the moment I can see.
All right. Okay. Thank you so much. And the next question would be for Bruno. Bruno, would establishing a Vietnamese authority on data protection be a viable option to manage the compliance process? What would be the advantages of a sole correspondent? The floor is yours.
So the draft decree introduces the Personal Data Protection Committee, which itself is under the Department of Cybersecurity, which itself is within the Ministry of Public Security. So this fulfills the role of Data Protection Authority, or DPA, that we can find in all the equivalent regulations around the world. So I'm sorry, I don't know the Italian one, but for the French is the CNIL. And you have the European Data Protection Board at the European level that is kind of consolidating all those data protection authorities. So for that matter, the draft decree is kind of aligned in a sense that it introduces that concept of data protection authority. However, having a sole authority it's not a problematic in such, might even have some advantages that I will enumerate just after. But as Filippo, you introduced, the constraint of having to be registered as a company processing personal data to the Personal Data Protection Committee, and having to be registered before you're allowed to process any data. No, this is clearly unrealistic, unless we have tremendous amount of resources that are provided by the government or by someone else. But that is one of the main points we advocated for. Please drop that constraint because it's too harsh. And if you look into the history, even the French Data Protection Authority tried to implement such a constraint and backed off because of lack of practicability. So that's a concern of ours about this Data Protection Authority. Now, about the advantages of having a sole correspondent, I think it's good to have a single source of authority, a single source of truth, to issue for instance, to issue the circulars, to centralize the code of practices that will be relevant to specific areas of the economy. For instance, we have the general data protection regulation, but for the healthcare industry, for banking and finances, or e-commerce, for instance, it has been mentioned as well, we will need to have a working group and to provide clear guidance for these actors. Otherwise, it will be impossible to reach a cost-effective compliance. So having a single authority that centralizes this kind of documentation or this valuable information is a great asset for Vietnam. And I believe that they will kind of integrate this to their e-portal and the e-government effort that has been undertaken. And I think it was released in December 2019. So Vietnam has the basic elements to promote the adoption of the regulation and to support the businesses into implementing companies, because this is what we need at the end of the day.
I see. So essentially, like, I mean, you're saying the sole correspondent will be like a body of different authorities all across different sectors. Is that what you want to propose to the authorities? So that, I mean, there's obviously a better, there's obviously a better regulation and a better authority in place.
So after, yes, I think we should keep one sole authority, but after, of course, the process of audit that has to take place in any company that we want to vet as being compliant with the regulation. This requires such a tremendous amount of resource that it cannot be held by a few, even 100 person in a department would not suffice. We need to certify companies. I think like the Big Four, for instance, would be very relevant, or maybe law firms or cybersecurity experts.
Sure.
Because after, when you go into the technique, you can look at the norm ISO 27001 and ISO 27701, which are the two norms the most relevant, and you see how big the work, how much effort is required to comply. So, to answer your question in one sentence, it's good to have one data protection authority, but we need to delegate the auditing effort to an ecosystem of auditors. Otherwise, it's not practical.
Sure. So, I mean, from my understanding, this is going to come into play by December 2021. I think there's like still a lot of work to be done till it actually comes into play in December 2021, from what I gather speaking and listening to all of you.
Yes, there is a lot of work. We have had words, so I really not claiming that it's true, but they even want to fast track the release of the decree to July.
Wow.
I don't know. Maybe I can tell. I will be able to tell you tomorrow, because I'm meeting with the MPS tomorrow. So maybe I have more information. I'd be happy to share. But
okay, thank you, Bruno. The last question that I have, the second last question that I have is for Simone. Simone, what are the most challenging steps of the compliance process, considering, you've been heading this company in China for many years and you've been dealing with a lot of companies on a day-to-day basis? And also, is it the collecting of information, the custody, or the compliance procedure the most difficult part of your job?
Let's start from the end. So, is it difficult to be compliant or not? Is really depending on how they will keep implementing the regulation. At the moment, it is not, because it's still in progress. So actually, it's really here we are talking about data protection for, of course, personal information. So HR part. I mean, if we speaking about the company, so HR, financial, and also, of course, whatever is related to website, e-commerce, so online information. For the moment, the requirements are basic and even not completely implemented. For example, if we think about financial information, the regulation says that it should be all sensitive and financial information, so HR and FI part should be stored in locally, so means in China. And these potentially have a big impact for companies, because think about all the software that the companies use for manage the company, so ERP system and financial system, HR system, that most of the time are centralized by the foreign companies in their headquarters and not localized in China or in Vietnam. So if the requirement is to have everything local, this could have a big impact for companies, but we really need to understand how deep they will implement this. So this, of course, the how difficult it is to be compliant is really depending on how they will implement and how strict they will implement the regulation. Potentially, I would say yes. So far, is not so complicated. What we can say for the moment, what we can mention, it's the approach for the different approach for data collection, data storage, and data availability. So of course, data collection requires and implies a system to collect data that should be, let's say, a system that can be, must be, of course, authorized and must be recognized by the authority as safe. So the way you collect data, you need to inform people how you collect, you need to inform the authorities how you store data in case they ask. So you need to have a clear policy. But what really matters more for it's also how you store data. So where you store in the company, how safe is the place where you store. Of course, it will be 90% the server. So how safe is your server if you are using encryption software or you are not using encryption software? If you are protecting your network from intrusion outside or inside, so firewall networking structure will be very, very important. And then backup. So of course, we were listening before that you need to keep information for at least 3 years. So backup is playing a key role. And then of course, they will, China, but also Vietnam, make clear how these data have to be available. So if you need to make it available upon request of the authorities, if they should be available all the time, and so they will they will create a centralized system on which you need to upload the data. So this is still in progress, but it's something that companies should start to think about.
Sure. So in China, like in Vietnam, there's a whole distinction now under the decree between personal data and sensitive data. Is there a similar construct like that exists in China? And if, is it like an automated system through which you segregate the information, or how is it done?
No, it's similar, but there is no automation. Also in China for the moment, we are of course ahead than Vietnam, but still the regulation is not clear at all. So we are learning with real cases and but it's no, for the moment there is no any real clear regulation on this.
Okay, thank you, Simone. The next question is for Bruno, which is which business sector would be most affected by the new regulations? Do you believe there would be any gap period of exemptions or softer rules before the full decree is implemented?
So in terms of impact, we have different clusters, different I would say categories of businesses, because I think the one that are the most at risk or the one that heavily rely on personal data but are not vital. For instance, the advertisement business or all the business that rely on kind of gathering your data through apps. I would not be judgy on that, but without your consent, and now they need to tell you exactly, to be transparent about what they do with your data. So probably those businesses might just disappear, or we'll see what happens. But if the law is really enforced, I think they are the most at risk. Then we have the businesses such as banking, insurance, which already have extremely high standards of cybersecurity and high resources. So it won't be very hard for them to comply on a cybersecurity level. However, they will need to be much more transparent with their users. For instance, if a bank Banks sometimes share their data to the insurances, or insurances pay agencies to gather personal data from user and target them with tailor-made policies, things like that, which is why you get sometimes weird messages on your phone or emails. So this will not really be possible with the new draft protection, because it is unlawful to echo to the first concept I mentioned during this webinar. So those will have to transform, however, to a lesser level than the first category I mentioned, which is advertising ecosystem. And then another one that is will be extremely affected, and not only in Vietnam, will be the GAFAM, like Facebook or the social networks. And for them, obviously, they will be extremely affected. They are fined in Europe actually already. And I'm really curious. I'm sorry, I cannot provide a clear answer for what is going to happen to them. But once again, maybe they are all talking tomorrow at this workshop, of course. So we'll have some answer tomorrow. And for grace period, so it's not mentioned yet. Of course, we have been advocating for that. We've been advocating for 2 years. Maybe if we can get 1 year, it would be good enough. And if not, I mean, there is no way all the companies in Vietnam are ready to comply day one of the regulation. So we'll see what happens there too.
Okay, interesting. So with this, I come to the end of the panel discussion, but we still have more questions for our panelists. And the first question that we have is for Mr. Bruno. Just 1 second, Gaia, could I open the poll?
Yeah, sure.
Thank you. So, Bruno, the question is that with respect to the principle of use limitation in data privacy, personal data can be used by authorities even without the consent of the data subjects. With this in mind, are there enough safeguards in the decree to ensure that there is no misuse of this personal data by the authorities themselves?
Okay, that is an extremely interesting question. And it stretches the fact that this is not only a technical issue, it is not only an economical issue, it is not only a political issue, but it's a bit of everything at the same time. So, so we did not advocate for this yet, but of course we are working on a harmonization between the GDPR and the Vietnamese personal data protection regulation. And why am I talking about a harmonization procedure? It is because this is at the core of the compliance. So if you look for those who are interested, if you look at Article 45 of the GDPR, you are able to be whitelisted as a country as compliant with GDPR or compliant enough, so it's very easy for companies to do business with European companies. So Korea has been whitelisted very recently. Japan is whitelisted too, and UK too. We have not that many countries, I think 11 or 12. And so if Vietnam wants to be whitelisted, we need to address this issue because it's really at the heart, and this is where you have a conflict. For instance, I'm a European citizen. I'm using a service in Europe, and so as such, I'm protected by GDPR. But this service, so the data controller to which I'm giving my trust into handling my data in conformity with the GDPR, in reality is relying on processors, one of which might be in Vietnam, for instance. And so my data might end up in the system of that processor. And that processor is under the law of Vietnam. And therefore, if the law of Vietnam, namely the cybersecurity law, enables the Vietnamese government to look into that system and to retrieve my personal data as a European citizen, we have a conflict between data that is protected by the GDPR on one side, but accessible by the cybersecurity law on the other side. And so that's a very specific point that is the node of the problem, and how to ensure that there will be no misuse by the authorities. It is extremely complicated. We need to, so what we push for, but once again, it's not official. I'm really insist on that. It's not official statement from the EuroCham yet. This is like the work of the Personal Data Protection Task Force only, but we're advocating to kind of use the warranty and judiciary agreement to kind of address this. But we are in uncharted territory 100%, so that's as much of an answer as I can give.
Sure. Thanks, Bruno. So actually, Simone, I would throw this question at you as well, because, you know, China, I mean, I cannot say much, but we all know that we have a similar issue when it comes to protecting of data and the whole thin line that we have between data protection and the authorities on the other hand. So how do you just see this whole thing playing out, like in the regulations? Is there some safeguard that we have, like as users, and to make sure that our information is not being misused by the authorities themselves?
Let's say that, I mean, it's still, I mean, also in China, I mean, actually it's not really well defined and regulated yet. It's still a topic under discussion. The law is still under improvements. So this is something not really, I mean, as far as I mean, I'm more a technical guy and know that, I mean, a specialist, a lawyer, or, but the experience I have with our clients is still something not really clear at the moment.
Sure.
So must be better clarified, because of course everybody, I mean, person and companies have to be compliant with, but they also need to know where that, I mean, how the data are managed from the authority, and I mean, they need to give access to the data for the authorities, but they also need to know how the data are managed, of course.
Sure. Thank you. And the next question that I have is again for Bruno, which is on the decree itself, which is, we want to know that what is the source of inspiration of this decree? Has it been just purely the GDPR regulations, or is it also been the Vietnamese government has also taken some inspiration from other developed economies?
So of course, we can see a clear inspiration from the GDPR. I know that the Ministry of Public Security asked the UNDP and EU-GU, so which are instances of the United Nations, to help on the matter. Yes, we can clearly see that the main concept of the GDPR are there. And I don't even want to say GDPR, I want to say like worldwide international regulation, because we have a pattern that is starting to emerge. And I hope that we will find a solution for this cross-border data transfer, and will be inspired by GDPR, but kind of a consolidation between all the regulation over the world, in Australia, Brazil, Japan, Korea, and Asia, and so on. But for the Vietnamese draft decree itself, it is aligned with the GDPR, but this so the main points are the registration constraints to operate on the Vietnamese soil, which is almost at the business license level, and that is mandatory before you can process. So that's not aligned with the GDPR, as I mentioned before. And the second one is the cross-border data transfers. We mentioned it before, but the same idea. Like it is much stricter than the GDPR, and therefore, I believe with the current technology available on the market, it's too costly. And so we have two ways of addressing this. Either we invest into new technologies, either we loosen a little bit the constraints, so it can be practical from a business executive perspective.
Sure. And I think what we need to keep in mind is at the end of the day, Vietnam is like a developing economy. So I guess, you know, when it comes to Europe, obviously, like those are developed economies. So there are obviously challenges associated with a developing economy. So the implication that a particular regulation could have in Europe versus what it could have in Vietnam would be totally different. So I think that's something which has to be kept in mind as well.
It is, however, even if Europe is developed, I don't think all the companies in Europe are complying with the GDPR yet, far from it. And yes, it's a very long process. And once again, without proper tooling, it's even in Europe, it's not happening to a sufficient extent. I mean, and sadly, the recent cyber security issues that we've heard of are illustrating that. On that, so it's something I've heard about. It's in discussion in France that the government might finance the digital transformation and finance give money to companies so they could reach a certain cybersecurity level. Because small companies, they cannot invest the money yet. Especially now in the COVID crisis, it's really messy for them to pull out a few €100,000 to hire a consultant and transform the system. So that's a lever that one can use to financial, public finance.
Sure. Thank you. So I think like the whole world, like what COVID has taught us is that digitalization is the way forward. So I think the decree is much needed because like the digital world is the future of the world for businesses, education, you name it, and that is the future. So I guess all economies need to work together and make the data protection regulations more and more strict, and obviously protect information and data of users to the best that they can. With that, yeah. I think we come to an end with today's panel discussion.
If there are no further questions from our attendees, and anyway, in case you can always email us if you have any further questions in the next few days, and we will make sure to put you in touch with the speakers who were kind enough to join us today. So with this, I would like to take this opportunity to thank again all of our speakers, starting from Consul Dante Brandi. Thank you very much for joining us. Michele from ICHAM, and of course, our speakers, Simone Ciampi and Bruno Sivanandan. And last but not least, my colleagues, Divya and Filippo. So with that said, thank you all once again, speakers and attendees, and we will make sure to keep you posted on our upcoming events. And again, if you have any questions, we're always available to answer yours by email or social media, wherever you want to reach us. Thank you very much.
Have a good evening.
Bye-bye.
Thank you.
Bye, thank you.
Thank you. Bye-bye. Bye-bye.
Bye-bye. Thank you.